Welcome, ladies and gentlemen, to today's LexCast. It is Sunday, January 8th, 2006. First story of the day is something that those of us that have been in Richmond or been living with for the last few days. Right after the new year came, there was a series of brutal murders in Richmond. There was two families, a family by the name of Tucker, husband, wife, and their daughter, whose last name was Baskerville, or the mother's daughter. And then there was the Harvey family, which is a father, mother, and two kids. I think one was 9 and one was 3 years old. The Tucker family was bound with tape, but the police haven't revealed how they were killed. The Harvey family was tied up and beaten, apparently with blunt objects, and their throats were slit. All four of them. The police yesterday announced that they had captured two people in Philadelphia who were involved in both of these crimes. The people are Ray Joseph Dandridge and Ricky Cooley Javon Gray, who were in Philadelphia and were caught with a car that actually belonged to the Tuckers. One difference, apparently, at the beginning between, well, there's a couple differences. The Tuckers are a black family, and apparently the people charged with the offense are black. The Harveys are a white family, and it's kind of strange. They don't really seem to have a reason for why the Harveys were killed. Initially, they were saying nothing was taken from the house. They're now kind of trying to say that, well, something might have been taken, or that it's just a crime of random violence. Something's wrong there. I'm not sure exactly what. I'm not sure we'll know exactly what went in the Harvey household or the Tucker household until this goes to trial, which apparently it will. And by the way, there's a brand new head prosecutor in Richmond. And Commonwealth Attorney Michael N. Herring said last night that a death penalty prosecution in these cases is certainly not beyond the pale. I will tell you, everything is there for consideration. Somewhat refreshing. While I'm not a fan of the death penalty has not been enforced in Richmond for a while, or at least common wisdom is that you can't get the death penalty in Richmond, and really hasn't been a whole lot of attempts, whereas some of the counties around Richmond are more rabid about it, and so you get a uneven enforcement, where in Richmond, think people get killed all the time and no death penalty enforcement, whereas you come across the county, you come across into my county, Chesterfield County, and murders are much rarer, but when they do occur, there's a much higher likelihood that a capital case will occur. Anyway, continue to watch this case. This was I took my information out of TimesDispatch.com, which is a local paper. However, you can see it around. I know that even the New York Times had something on it today. And now, on to the next story. The second story for today comes from the Seattle Post-Intelligencer, and it's about a case from Utah which has a Fourth Amendment case which has been accepted by the Supreme Court of the United States. Now, this case is Brigham City against Stewart. It is a case wherein the police arrive at a residence where there's a party going on, underage drinking, adults drinking apparently too, or at least adults present. They come up to the house. I think it may have actually entered the backyard. I read the case very, very quickly. And if you're interested in it, I suggest you go back and read the Utah Supreme Court's decision. But my take on what I read out of it was that police officers come up to the house, come up to the door, they look in, they see that there's several adults, 3 or 4 adults, trying to bring some underage youth who's drunk and out of control. They're trying to keep him restrained. The kid breaks free. He strikes one of the adults, at which time the adults again try to restrain him. The police enter the house yelling, "Police, police." They charge people with, corrupting minors, some such charge. Goes to the trial court, and the trial court throws it out, saying that they needed a warrant to go into that house. The state appeals it to the Court of Appeals, and the Utah Court of Appeals agrees with the trial court, says yes, they needed a warrant to go into the house. And then again, the state appealed it to go to the state Supreme Court, and the state Supreme Court agreed again with the trial court, saying, well, first they talk a little bit about whether this should be decided under the state law, state constitution, or federal constitution. They generally decide to go with the federal constitution. I think, if I understand the basic reasoning, was because it wasn't preserved properly under the state question. And then they go on to something that's kind of like a community caretaker doctrine, and they examine it under that and decide it doesn't apply. And then there comes the point, which is the serious point of the case, whether there were exigent circumstances. And the Utah court says no. They at least had to knock and announce themselves before they entered. They didn't do that, and therefore they violated the Fourth Amendment. Now, they talk a little bit about whether or not they should have been required, or if it was a domestic situation where it was a husband and wife or something, whether or not there was exigent circumstances. But they say that this is obviously not that sort of a situation, and therefore they don't have a domestic situation that's exigent to bring them into the house. And now this has been appealed to the Supreme Court. Kind of a really minor case to get appealed to the Supreme Court, and you wonder why they would take it. Although, sometimes appellate courts seem to take minor cases so they can set precedent without being really clogged with some really nasty emotional situations, like a murder or a rape or something, so that they can actually say, this is the law, and you will follow it. And so when it comes down to that nasty murder or rape case, they've already set the precedent. I can't say that that's what's going on here, but you kind of got to suspect it when they do something, take something as minor as contributing to the delinquency of a minor and raise it all the way to a question in the Supreme Court. With that, ladies and gentlemen, let's move on to the third question. The third story for today is from the Dayton Daily News, where they report that a 13-year-old who was left at home by his mother to care for his younger siblings, and who choked one of them to death with an iron bar, that his conviction for murder was upheld by the Supreme Court. Apparently he was convicted to be held at a juvenile facility until 21, and if he didn't do everything the judge told him to do while at the juvenile facility, he would then get 15 years to life in an adult facility. Now, I'm not sure what he's supposed to do at the juvenile facility, and to be honest with you, juvenile facilities I've seen, now I do deal with the one where the worst go to, but juvenile facilities I've seen, nothing good happens to kids at these places. The mother, on the other hand, got a manslaughter charge, involuntary manslaughter no less, and I think she got 18 months. Yeah. So that's the case out of Dayton. Just want to let you all know about that, and now let's move on to the next issue, next story. From the Washington Post, I hope you all remember a few weeks back I did a video cast, LexCast, about the General District Court judge in Fairfax who was refusing to uphold the presumption of guilt, which is found in the Virginia DUI statute. You have a certain amount of alcohol in your system. The circuit court there, a judge there, took the case, and as I said before when I was discussing this, prosecutors can just dismiss this in General District Court and get it up to the circuit court. And that's what they did. And the judge there, Judge Woolridge, ruled that the law as written would be unconstitutional. And God help us if we were actually to read the law as it's written in the books, so that we might, your basic layperson might understand it. But that as interpreted under Virginia law, the courts can interpret it so that it just means a permissive inference, which is what I said would happen. And therefore, since it's merely a permissive inference, there's no requirement of finding anyone guilty. If you're permitted to infer, you're permitted not to infer. And therefore, since there's no requirement, it's a constitutional statute, and it stands. And, I think that's right under Virginia interpretations. I really wish that some legislator would get in to the General Assembly and go and actually fix the language of all these statutes so that it said permissive inference in the statute rather than rebuttable presumption. But, that's kind of wishing on a star. With that, ladies and gentlemen, let's move on to the next story. Next case comes from the Committee to Protect Journalists. It's about a Paraguay case. The Supreme Court in Paraguay has upheld a criminal defamation case conviction against a newspaper editor by the name of Aldo Zuccolillo, or maybe Zuccolillo, depending on whether the double L's are pronounced. I don't know, but I'm American. I'm going to pronounce it Zuccolillo. He has been found guilty of criminal defamation because he said that a senator from the ruling Colorado Party, Juan Carlos Galaverna, or Halaverna, whichever, was corrupt, embezzled, and abused his power. I thought that's pretty much what newspapers did 24 hours a day about politicians, but maybe it's a little bit different in Paraguay, and so they were a little bit upset about this. They found him guilty. The Supreme Court of Paraguay upheld this conviction. Next step seems to be to take it to the Inter-American Court of Human Rights in Costa Rica. This is an organization to which the United States is not a signatory, or at least we don't recognize their jurisdiction, or however it works exactly. Although the Inter-American Commission on Human Rights is located in Washington, D.C., and apparently it's the referring body to this court, so I don't know how that works. But apparently this court in Costa Rica has already addressed this kind of case at least twice, and the first time it said that even having this kind of case is contrary to human rights. Criminal proceedings of this type violate the American Convention on Human Rights because they are not necessary in a democratic society. So they're not needed, so therefore they're not valid under international law. And it also had said in another case, critics of public officials must have leeway in order for ample debate to take place in matters of public interest. So it's pretty obvious that if this does go up to this court, that they will overturn it, or I'm not sure exactly how it will work exactly. They will at least say that it's incorrect, and the Paraguay courts and the Paraguay government will have to decide how it's going to deal with it from there. But they are a signatory to whatever makes this court valid. And now on to the next case. And we find from inside Bay Area that in Maryland, it is not against the law to moon somebody if you're upset with them. It's a speech matter. There was a gentleman involved in a homeowners association debate. He sees somebody from the other side of the debate, apparently decides imposing its will upon him, walking down the street or going to her house with her 8-year-old daughter, and he moons her. Well, the court in Maryland finds that that's speech. That's not indecent exposure. And the quote from Circuit Court Judge John Debelius III is that, he makes the normal words, normal kind of soothing tones. This is disgusting, wrong, improper, not a proper society, blah, 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 but it's still speech. And then he also finds that the buttocks area is not a private area, such that it shouldn't be exposed in public. And the money quote here is, if exposure of half a buttock constituted indecent exposure, any woman wearing a thong at the beach on Ocean City would be guilty. Defendant's attorney goes further and tells us that in Maryland that it's not illegal to expose your buttocks. In Washington, it's not illegal to expose your buttocks. But he does specifically warn us that if you're going to Virginia, you're not going to get away with this kind of thing. And finally, in Italy, they get this from Yahoo News and Reuters, a man is suing a priest and the Catholic Church, actually he's trying to get criminal charges against them, for abuse of popular belief and impersonation. And his argument here is that I started this lawsuit because I wanted to deal the final blow against the church, the bearer of obscurantism and regression. And I guess that qualifies as his first abuse of popular belief charge. His impersonation charge is based on this. The church constructed Christ upon the personality of John of Gamala, a first century Jew who fought against the Roman army. Now, if anyone actually believes out there that in Italy you're going to get a decision that, 2,000 years worth of theology is incorrect and that, Jesus really wasn't Jesus and all sorts of stuff like that, I think you're probably in La La Land. I think this guy was insane too, probably, except for the fact that, as it mentions in the article, he has a book, Shock of Shocks. Could this possibly be a publicity stunt for his book? In my book, The Fable of Christ, I present proof Jesus did not exist as a historic figure. He, meaning the parish priest, must now refute this with proof of Christ's existence. Interesting. So, I can assert that, Alexander didn't exist. And I'm going to write a book, 400, 500 pages, going to say that Alexander is actually based upon a Roman general from the 3rd century A.D., or let's make it a little further back. We'll say 1st century A.D., Roman general, all based upon him, and all this stuff is just, sterile conjecture and fable and all this. And so then I can turn to anyone who has made, say, a movie about Alexander, and I can sue them and say it's fraud, and that they have to prove, or I can bring them to court on a criminal charge, I guess in Italy, and tell them that they have to prove that Alexander actually existed, however many thousand years ago it was. Kind of an interesting way to try to approach the law and criminal matters. And anyway, ladies and gentlemen, that's my final statement for today. I just wanted to leave you with that one last case, which I thought was kind of interesting. And with that, I'm going to close it up for today. I tell you, as I always say, if you're interested in anything I've said here, look it up yourself. Do more in-depth research than I did, because I didn't do that much in-depth research. And I think I'm going to go to a format change here for crim law. It's going to be more like a Lex TV thing rather than crim law. I think I'm going to do something that kind of see going on in different places where every couple days I'm going to put up a video and talk about 5 or 10 interesting things that have caught my eye. And I might do a couple little statements here and there in the blog. And I'm obviously going to allow anyone who has blogging rights to continue to blog and encourage them to on crim law. but I think I'm going to try to go more with a video blog from now on. And we'll see how it works. It may be too time-consuming. It may work out perfectly. Anyway, it's been 3 years for Crimlaw. Actually, I think it's 3 years as of the 12th for Crimlaw, the blog. I'm not going to totally shut it down. But it's time to kind of experiment with something else. And we'll see how the video log goes. So, ladies and gentlemen, welcome to a new year and a new format, or semi-new format. And with that, I'll wish you all a Happy New Year and say good day.
Kautta historian ovat suurmiehet tavoitelleet maailman herruutta. Yksi toisensa jälkeen he ovat epäonnistuneet. Kunnes...
Kaisari Birch on täällä!
Me teemme tästä maailmasta paremman paikan.
Ehdottamanne toiminta on ensimmäisen direktiivin vastaista.
Me varmistetaan P-liiton syntyminen. Keinolla millä hyvänsä.
Vallanpitäjät ovat voimattomia tulevaisuuden teknologian edessä, ja uusi maailmanjärjestys astuu voimaan.
Taktisesta puuttuu edelleen tuoli.
Tehotaso 96,3%.
Täyskieroutuminen. Nyt!
Edessä on uskalias matka.
Otaksun, että olemme tulleet jonkinlaiseen oman maailmamme peiliulottuvuuteen.
Täällä kapteeni Sheripai, Babel 13.
Täällä keisari Pirk, P-liiton ylijohtaja.
Voisitte vaikka tuoda miehistönne lomailemaan hetkeksi.
Mutta keisarilla on muuta mielessä.
Muinaiset ennustukset käyvät toteen. Suuri pimeys tulee, ja me kaikki kuolemme.
Kun rauhan keinot on käytetty.
Maan sotalain pykälä 42 perusteella tuomitsen teidät kuolemaan rikoksistanne ihmiskuntaa vastaan.
On aika lämmittää tuikkupankit.
Amikoluokan hävittäjät ovat saavuttaneet optimaalisen tulitusetäisyyden.
Kuinka saavutettu? Onko jotain sanottavaa ennen kuin me räimitään teidät palasiksi?
Potkitaan nuo paskiaiset pois tästä galaksista.
Tulta!
Ja minä aion täyttää velvollisuuteni maata kohtaan.
Paadetaan se!
Pirkin, ovelus iskee jälleen.
Jiha! Tämä on täydellinen suunnitelma! Täydellinen suunnitelma, tosi. Info! Kompresso! Jotain!
Avaruuden hiekkalaatikolla ei ole tilaa kahdelle.
Taistelemme viimeiseen asti.
Syö valopalloja. Tulta!
Joo niin. Ota vähän rennommin.
Valmistaudu. Vuosisadan turpakäräjiin.